Welcome to the deep dive. We take stacks of information and really try to get to the core of what you need to know. Today, we are diving into a legal document that is, well, it's dated today, August 19, 2025.
Really fresh off the presses, so to speak.
Exactly. And the story it tells sounds almost unbelievable. We're talking serious allegations here. An attorney, a law firm, a doctor.
All allegedly involved in a scheme.
A scheme involving copy-paste surgery reports, think about that, and refusing to withdraw court statements they supposedly knew were false. So our source for this deep dive, it's a summons and verified complaint filed in the Supreme Court of New York, Kings County.
Right.
It outlines this lawsuit by Union Mutual Fire Insurance Company against William Schwitzer Associates, PC, that's the law firm.
And specific attorneys, too.
Yes, Michael Mahan and someone they're calling John Doe Esquire for now, a placeholder until they identify maybe another person involved.
Yeah.
So our mission today is really to unpack these, frankly, astonishing allegations.
Yeah.
Understand the details, what exactly is claimed to have happened, and maybe explore what this means, for the integrity of our legal system, our medical system.
Well, what's so compelling here, I think, is how just one legal document can potentially expose this whole tangled web of alleged misconduct.
Mm-hmm.
It really puts a spotlight on truth, on accountability, especially for people like lawyers, doctors, people we're supposed to trust.
Officers of the court, medical professionals.
Exactly. So this deep dive, it should reveal the layers, the accusations, and the pretty significant implications for anyone needing legal help or medical care.
Okay, let's unpack this. Where does it all start?
It goes back to an earlier case, right?
Yes, an underlying personal injury lawsuit. So the defendants in this new complaint, the Schwitzer law firm, the attorneys, they're representing two people.
Carlos Luis Toribio and Yesenia Mariel Alcantara.
Right. In a negligence claim against a company called 1936 Bath Avenue, LLC.
Who are insured by Union Mutual, the plaintiff in this case.
Precisely. And the original claim, a supposed ceiling collapse in an apartment back on June 29th, 2021.
Okay, a ceiling collapse. Sounds straightforward enough initially.
But here's where it gets really interesting right away in the complaint. It raises questions about the collapse itself.
How so?
Well, it alleges the claimants testified that a photo showed the scene accurately right after it happened.
Okay.
But this photo supposedly shows pillows and blankets.
Yeah.
Well, they weren't covered in dust or dirt.
After a ceiling collapse.
Exactly. And they look like they might have been moved before the collapse. Plus, get this, a light fixture just inches away.
Let me guess. Untouched.
Intact. Functioning. And also no particulate matter, no dirt on it.
Wow. Okay, so those details, as alleged, those are pretty big red flags in any investigation, aren't they?
You'd think so.
Absolutely. Those little inconsistencies, seemingly small things like clean pillows or working light, they're often the first threads you pull, and they can unravel the whole story, or at least prompt much, much closer scrutiny. Suggest the incident might not be quite what it seems.
So if the incident itself is under question, what about the injuries they claimed?
That's the next layer.
Okay, so on the day of the incident, Toribio apparently told first responders the ceiling hit his chest and neck. Complaint was only neck pain.
Okay.
At the hospital, though, his main complaint shifted. Neck, left knee, back of head. Pain level dropped from 5 out of 10 to 2.
So, changing symptoms, decreasing pain.
And then fast forward to January 2023 testimony. He says he was sleeping on his stomach and debris fell in his back.
That's a completely different mechanism of injury.
Right. And Alcantara, her complaints also varied quite a bit that morning. Plus, neither of them had any visible injuries, no swelling noted, didn't claim they lost consciousness.
It's fascinating how these initial kind of inconsistent reports, how they set the stage for the later medical claims.
Yeah.
That early variability, it's often a clue, a signal that maybe the more severe claims made later on are built on shaky ground.
Which brings us to the doctor at the center of this, Dr. Alexios Apazidis.
Mm-hmm.
Both claimants were apparently referred to him. He saw them about 10 months after the incident.
10 months later. Okay.
And here's a key detail the complaint highlights. He allegedly saw them on a case-lam basis.
Meaning he gets paid out of any lawsuit winnings.
Exactly. His payment would come from the proceeds. And this was even though Alcantara apparently had Medicaid available.
That LIN arrangement is always something investigators look at closely in these types of cases.
Right. Now, here's a really explosive part. Dr. Apazidis supposedly performed major surgeries. An ACDF, That's an anterior cervical discectomy and fusion on Alcantara.
Okay, mech surgery.
And a PLF, posterolateral fusion on Toribio.
Lumbar spine surgery. These are serious, complex procedures.
Very serious. But the absolute heart of this complaint is the allegation about the operative reports for these surgeries.
What about them?
They were allegedly identical, verbatim, less patient name, level, laterality, and implant size to reports from other patients.
Identical. How many others?
At least 14 other patients for Toribio's report. And at least 28 for Alcantara's.
28 verbatim reports for spinal fusion surgery? That's staggering, if true.
It is. Imagine surgery reports, right?
Yeah.
They're meant to detail unique, complex, individual procedures.
Absolutely. Highly specific to the patient, the anatomy, what happened in that room.
But here, the allegation is they were nearly identical across dozens of people. It suggests, well, a template. A copy-paste job.
The implications are huge. It completely undermines the credibility of those medical claims, doesn't it? Suggests a systematic issue, not just a one-off mistake.
And the complaint dives into specific contradictions within these reports, too.
Like what?
Well, for Toribio, Apazidis apparently affirmed Toribio's prior neck and back pain from a 2018 accident was resolved by summer 2020.
Okay.
Yet his April 2022 report allegedly left out a prior lumbar MRI, barely mentioned a prior neck issue.
So omitting relevant history.
Seems like it. And then it says Apazidis affirmed contradictory things about that 2018 MRI, claiming both no pre-existing findings, none at L4, L5, and also a disc bulge at L4, L5.
You can't have it both ways. That doesn't make sense.
No. And the operative report claimed left-sided nerve impingement. The complaint says that was flatly the opposite of the MRI finding, which was right-sided, with no impingement noted.
Wow. Okay, that's specific.
And how can a rent or tear in the posterior annulus be described as otherwise intact in 15 different reports?
Right. That phrase itself seems problematic across multiple unique surgeries.
Now, for Alcantara, the complaint states she actually denied pain and a pre-op appointment, but Apazidis recommended surgery anyway.
Surgery without recorded pain.
That's the allegation. And her verbatim identical 4-page operative report used for 28 other patients.
Incredible.
It gets weirder. There's mention of a plastic surgeon's report for Alcantara that referred to her as a 26-year-old male.
Wait, what?
Yeah, and described unrelated medical history not found anywhere else. Plus, discrepancies in anesthesia times.
Okay, this sounds like a cascade of errors, or worse.
And while Apazidis' report claimed a specimen was submitted from a partial corpectomy.
A bone sample?
Yes, but the brief operative report apparently said no specimen was submitted, and hospital records allegedly lacked documentation of any bone specimen ever existing.
So conflicting accounts about whether surgical material was even collected or sent to pathology.
Exactly. So what does it all mean? The complaint is pretty blunt.
I bet.
These weren't just similar reports. They were allegedly templates, generic documents passed off as unique medical findings, all to support damages claims in lawsuits.
It really raises an important question, doesn't it? If the documentation, the very record of the surgery, is allegedly copy-pasted and potentially inaccurate.
What does that say about the actual care provided?
Precisely. Beyond the legal fraud aspect, what about patient safety? It's deeply concerning.
It absolutely is. Okay, so we have these alleged medical fabrications, these copy-paste reports.
Right.
Now, the focus shifts. How does the law firm, the attorneys representing Toribio and Alcantara, fit into this?
Did they know?
That's the core allegation in this lawsuit. The plaintiff, Union Mutual, alleges that the defendants, Mahan, John Doe, the Schwitzer firm, they had actual knowledge that these Apazidis reports and affirmations were false.
Actual knowledge. That's a high bar, but critical.
And, crucially, that they refused to withdraw them from the court case.
Even after knowing.
That's the claim. And the timeline they lay out for this alleged awareness is really, really detailed.
Okay, let's walk through that.
Right. July 23, 2025. The defense lawyers, Mahan and the firm, filed their opposition to a summary judgment motion in that original injury case.
Trying to keep the case alive, basically.
Yes, arguing there are factual disputes needing a trial. And they rely on these Apazidis affirmations, the ones now alleged to be false.
Okay.
The very next day, July 24th, plaintiff's counsel sends an email directly to Mahan, explicitly telling him about the alleged falsity of the reports, the grounds for that belief, and mentioning that similar issues with Apazidis reports had led to other cases being dropped.
So, direct notice. You can't say he wasn't told.
That's what the complaint suggests. Mahan apparently responds on July 25th, says he won't investigate unless there is a filing.
Not my problem until it's officially filed.
Seems to be the gist. So plaintiff's counsel obliges. July 28th, they file a third-party action directly against Dr. Apazidis himself.
Suing the doctor.
Yes. Alleging fraud, aiding and abetting fraud, deceptive practices, even RICO violations.
RICO? Wow, they're not messing around. That's usually reserved for patterns of criminal activity, like organized crime.
It definitely signals how seriously they view this alleged pattern. Then more emails go out to Mahan and the firm. Late July, early August.
Providing more evidence.
Yep, sending more of those identical operative reports. The count is up to 28 by this point. Warning about the new lawsuit against Apazidis, offering more time to investigate.
They're building a clear record of notification.
Seems like it. By August 5th, they file something called an order to show cause, basically asking the court to take judicial notice, to formally recognize as fact the identical nature of these reports.
So, putting it directly before the judge in the original case.
Correct. Now, if we connect this timeline to the bigger picture,
it really shows this persistent effort, right, to inform the law firm about these alleged problems before this current lawsuit against them was filed.
yeah,
It raises very serious questions about the choices made by the firm and its attorneys, especially given their duties as officers of the court. They got repeated, specific warnings.
then comes what seems like a critical turning point. August 8th.
What happened?
Mahan reportedly has a phone call with the plaintiff's counsel. According to the complaint, he says the Schwitzer firm intends to drop the case. They're just waiting for final approval.
Okay, so it sounds like they're going to withdraw it.
That's what was apparently said. And that same day, August 8th, this whole story breaks in the news. Newsday runs it as a cover story. Becker's Spine Review, the National Herald. They all report on these allegations.
So it's public now, major scrutiny.
Huge scrutiny. But then, August 13th, the complaint says Mahan changes course completely.
He goes back on it.
He advises plaintiff's counsel, quote, "At this juncture, we are not withdrawing on this matter. I have been advised."
I have been advised, so someone else made the call.
That's the implication. The complaint suggests he was overruled by this John Doe Esquire figure at the Schwitzer firm.
Wow. So the decision to push forward, even after supposedly knowing about the alleged fraud, even with public reporting.
That decision is absolutely central to these new allegations of deceit and collusion against the firm itself.
It really paints a picture of a deliberate choice being made, despite all the warnings and the public spotlight.
So what's the immediate fallout from that decision? The very next day, August 14th, that summary judgment motion gets argued in court in the original case.
The one they were opposing using the Apazidis reports.
Exactly. And despite all these notifications, all the evidence presented about the identical reports, the defense argues, relying exclusively on the knowingly false Apazidis affirmations, that they create a triable issue of fact.
They doubled down in court.
They did. And what was the outcome?
This is critical.
The court actually denied the motion regarding Alcantara's neck claims and Toribio's back claims.
Meaning the case continues on those specific injuries.
Yes. Effectively, the court relied on those contested affirmations. However, the court granted the motion for all other claimed injuries.
So a partial victory for the defense based on the allegedly false documents.
That's how the complaint frames it. It states, quote, "Defendants' attempted deceit upon the court is now a completed deceit."
Because the court relied on information they allege the defendants knew was false.
Precisely.
Well,
so what does this mean for the legal system? What are the stakes now?
big ones, I imagine.
Union Mutual is suing the law firm and attorneys under a specific New York law, Judiciary Law, Section 487.
What does that law do?
It's pretty powerful. It says an attorney who is guilty of any deceit or collusion with intent to deceive the court or any party forfeits treble damages.
Treble damages, so triple the amount.
Triple the damages suffered by the injured party. Plus, they're also alleging aiding and abetting common law fraud.
So this really underscores the high duty attorneys have, doesn't it?
Absolutely. The complaint argues this isn't just, business as usual.
Right.
It emphasizes that lawyers are officers of the court. They can't just hide behind zealous representation if it means allegedly breaching ethical duties, misleading the court, subverting the whole truth-seeking process.
Zealous representation has limits. It doesn't mean you can participate in or ignore fraud.
That's the argument.
Yeah.
So Union Mutual is seeking those troubled actual damages, likely their costs defending the original suit, but also compensatory and punitive damages for the alleged fraud.
Punitive damages, that's meant to punish and deter, right?
Yes.
Because the alleged conduct was so bad.
Yes, they use terms like willful, wanton, and morally culpable to describe the alleged conduct.
And beyond the legal and financial mess. Is there a human cost mentioned here?
There is, and it's quite jarring. The complaint details an unsolicited witness who came forward, Crystal Hodgson.
Unsolicited, she just reached out.
Apparently so, on August 15th. She came forward with what is allegedly the 29th identical operative report from Dr. Apazidis.
Another one.
But her story. She allegedly suffered severe complications after her surgery. An acute vertebral artery dissection, jugular blood clot, carotid aneurysm, multiple stroke.
Oh my God, those are incredibly serious, life-threatening conditions.
Horrendous.
Yeah.
And the complaint claims these complications weren't properly documented, that her treatment was delayed and made worse by the copy-paste reports.
How so?
Well, it alleges Apazidis instructed her to go to an ER after her surgery was denied by workers' comp, potentially to get around that denial. And the generic reports obscured the reality of her condition.
So the alleged paperwork issues had real devastating health consequences for her. That's the picture painted. It just underscores, beyond the money, beyond the legal arguments.
There are real people potentially harmed. It hits home how alleged misconduct, isn't just abstract. It can destroy lives and deeply erodes public trust.
Yeah. Trust in doctors, trust in lawyers, trust in the systems themselves.
Exactly. When things like this are alleged, it makes everyone question the integrity of the professionals they rely on. So we've taken a pretty deep dive today into this extraordinary legal complaint. Allegations of deceit, collusion, involving attorneys, a doctor,
affecting an injury case, an insurance company,
and potentially dozens of patients like Mrs. Hodgson.
Yeah, what's really striking, I think, is how one single document, this verified complaint, can just lay bare such a complex, multi-layered alleged scheme.
It's intricate.
It really is. And diving into this very current legal proceeding, it leaves you with a pretty important question, doesn't it?
What's that?
Well, in this age of just information overload, constant claims flying around, how critical is it that we really demand, uncompromising truth and accountability, especially from the professionals we trust with our health, with our access to justice?
It feels more critical than ever.
It does. So maybe something for you, the listener, to think about. What stands out most to you about the responsibilities we place on those who uphold the law, those who practice medicine, particularly when the stakes, as we've seen alleged here, are just so incredibly high?